Hi there. Welcome to episode 8 of Sea Lawyer Station. My name is Jose Mallari. Talking about death is awkward. Planning for it does not have to be. I will be joined today by Mark Ignacio. He is an estate and trusts attorney who can simplify the tricky world of wills, trusts, and probate to help you protect your family's legacy. Here we go. Attorney Mark Ignacio, welcome to Sea Lawyer Station.
Thanks, Jose. Appreciate it.
How are you?
Doing great.
Thank you for sitting down with me today to discuss a very important topic for our viewers. As a token of my appreciation, I'd like to give you a box of chocolates.
Right on. Appreciate it. Thanks.
Yep.
Great.
Mark, you are a member of the California Bar and licensed to practice law in the state of California. But your firm focuses on estate planning, probate, and trust administration. Why did you choose to focus on those three practice areas?
Yeah. It's a great question there, Jose. Thank you so much for, again, allowing me to be here and to introduce myself to the rest of your audience. So, as we all know, Benjamin Franklin said that you can't really escape life other than death and taxes, right? Mm-hmm. Death and taxes. Those are going to be the inevitabilities of everything here.
Yeah.
So specifically with the death component, it's a necessary type of thing here that we all have to experience. Mm-hmm. And I initially wanted to be a doctor.
Okay.
I wanted to help out people in the medical field, so on and so forth. And that eventually didn't come to fruition. During my high school days, I got selected for this writing competition, and they flew us all out to Sacramento, where I was able to meet a lot of judges, meet a lot of attorneys, and I was really inspired by the law. And came home, told my parents that, hey, I decided to switch focus and want to be an attorney now. So they were great, very supportive with all that. From that period, I really wanted to focus on the law because I knew that this is where I was called to help make an impact, help make a difference in people's lives. Throughout my career, from being a law student to being just an early attorney, I was trying to find my way through where in the law I was supposed to be going to. And in my third year of law school, unfortunately, my stepfather passed away. And he had a trust, but it was really incomplete. And as a result, my mom and I had to go through probate. It was completely avoidable. It was completely unnecessary. And that helped fuel specifically my drive to help those people in my situation. Hey, I don't want any of my clients having to go through probate. I don't want anybody having to experience what my mom and I had to go through. It's completely unnecessary here, right? So estate planning, probate, trust administration law kind of helped find me in that way because of the life experiences with the death of my stepfather. So I've been doing this for over 13 years now, and it's an incredibly rewarding experience. There is such a need for folks to be educated about what all of this really entails, where if people do not conduct proper planning, there's going to be some real harsh consequences. Again, my mom and I had to suffer through all of that. So that's where I feel like I'm called to really be in these types of law here. The estate planning, probate, trust administration, they're all very, very complementary of each other.
Mark, so that our viewers may know more about you, could you give us a brief life story? Where were you born?
Sure.
Where you grew up, your education, professional experiences, and up to the present time?
Yeah, certainly. So I was born actually in the Philippines. I was born in Bulacan, Santa Maria, Bulacan. Was there for the first 6 years of my life and came here when I was 6 years old. Mm-hmm. So funny slash not funny story. When I was young, when I was around 6, 7 years old, I had a very, very thick Filipino accent. It doesn't sound like it right now, right? It doesn't sound like it right now. So because of my thick accent, I was made fun of when I was in school. So the kids were just like making fun of me. So I remember coming home crying, like so the school wasn't too far from my house. I was crying, like, oh my gosh, I'm being bullied, I'm being all that. So at that time, my stepfather, who's a white guy, he was saying to my mom, hey, from now on, we do not speak Tagalog in this house. So as a result, I stopped speaking Tagalog. I can understand it a little bit here, right? So again, it was just like a complete 180. It was all Tagalog all the time. Now it's all English all the time. I know more Spanish than I know Tagalog. So that's kind of what happened as far as just like me not speaking Tagalog, but I do understand a bit. So I grew up here in San Diego, specifically here in the East County. I attended elementary school over here in nearby St. Martin's Academy. I did my high school at St. Augustine High School, the only all-boys Catholic high school here in San Diego. I went to USD for my undergrad. I have a degree in psychology with minors in English and philosophy. I completed that in 3 years. I completed that in 3 years. In retrospect, I wish that I would have stayed an extra year in college. It was a lot of fun, but I knew I needed to kind of move forward here, right? And then when I was applying for law school, I happened across this one school in St. Paul, Minnesota, called Hamline University. They offered me an incredibly generous scholarship, and this would be my first time leaving San Diego. So I took that opportunity, and I spent my first year of law school over there in St. Paul, Minnesota. Again, first time being away from Southern California. It was a really cool experience being there in the Midwest, really great people over there. But my stepfather, he contracted some sort of rare form of cancer, so I had to come back home. And at that point, the only schools that were taking transfer applications was Cal Western here in downtown San Diego. So I applied, I got accepted. I finished up law school over there and took the bar, passed the bar, and gosh, I've been practicing here again for about 13 years here. So it's been an absolutely incredible experience in dealing with all of this. I'm heavily involved with our faith community, our Catholic faith community here in San Diego. I serve on the finance council here. That's frankly the most important part of my life is my faith and my family. So again, it's just been very rewarding type of past 40 years of my life that I'm here right now.
Any other field of practice that you engaged in other than this?
I did some landlord-tenant law. Very early. My family owns several rental properties, so naturally I was accustomed to that type of law. Mm-hmm. But again, that I wasn't called to pursue that. It was just this particular law that was calling me, and I'm frankly just like couldn't be happier in doing that.
Going back to your practice areas, could you give us a brief overview of estate planning, probate, and trust administration? Why are they important? The difference of one from the others, and how do they intersect with each one?
Right. Great question. So the main theme of those concepts and those particular practice areas here, Jose, really deals with death and incapacity. Well, what happens when you ultimately pass away or you're not in your mental state of mind? Do you need to get the courts involved? Meaning, is probate necessary? Or have you already obtained and crafted a customized plan for you, which is estate planning that dictates and details what you want to have done? So a lot of folks think that, oh, you know what? I'm a single person. I only have one child. Everything is going to go to my child. So why even bother creating like a will, right? I believe the statistic now is in America, I think it's about only 55% of people have created valid wills. So that leaves a pretty large amount of people who are just kind of leaving their legacy up to what their specific jurisdictions have. It's always good to be able to customize and control a little bit of what we're able to dictate, right? Rather than what the other jurisdictions, other laws may specifically want us to pursue here. So estate planning, incredibly, incredibly important, because at the root here, Jose, it is an act of love. It's saying, hey, kids, I love you enough so that you don't have to go to courts. So let me make my plan here for you. Let me be as clear and as objective as possible so that my intentions are hopefully going to be held true, so that there's no court involvement, there's not going to be much fees, so on and so forth. It's going to be as smooth as possible. So that's where, if that is going to be taking place, then that's where trust administration comes in. Okay, now that somebody has passed, how do we administer the trust? How do we make sure that the grantor's wishes are appropriately held? That's where all of this comes in. Do we want to leave it up to the courts, which is probate, or do we want to have something more customized, something that we want to have our own stamp of approval? That's where estate planning comes in, and after it passes away, that's where trust administration comes in as well.
Now, I want to dive in a little bit on
Sure.
estate planning.
Sure.
What are the key components of a solid estate plan?
Yeah, great question again. So think of an estate plan as like a wheel on a bike, right? So you have the tire, you have the actual wheel itself, the assembly, but there's several spokes that comprise it. Those spokes are going to be necessary to really comprise that actual wheel. So think of an estate plan again as that wheel and different spokes as a different components of that estate plan. So you have your living trust, that's going to be one spoke. You have your will, pour over will, that's going to be another. You have your healthcare directives, you have your powers of attorney, you have HIPAA authorizations, you have all of that there, right? So that's what you want. You want a comprehensive estate plan. Not just some sort of a la carte documents that may complement with each other, that may work with each other. So you want to have something that's really comprehensive, and you want to make sure that this is going to be properly maintained throughout your life. I don't know how many times I've seen old estate plans that were like 30, 35 years old that obviously I haven't produced, and they think that they're going to be good to go, right? And I review and I read it, and I see that they've made their deceased kids as the agents for their health care. Well, what happens if you get sick? Those kids obviously are not around anymore. So who's going to be making medical decisions for you? You need a healthcare directive. The trust doesn't do that. I've seen these old stale trusts where they have really unnecessarily complicated language. Probably want it to be a little bit more simple, right? They have old assets that are no longer there. They have new assets that's not in the trust. That wheel is going to be incomplete. You need all of these different functions here so that wherever you're at in life, you won't ever need a stranger. You won't ever need a judge to be able to interpret what it is that you want. Having this comprehensive measure will ensure that. If you don't have things in place, if you have things that are old, if you have things that are incomplete, you necessarily will need the probate courts. You will need a judge to help interpret all of that.
Common question I hear is that, is estate planning only for rich people?
Yeah, it's not. It's not. So think about this here, Jose. So you have two kids.
Yes.
Right? You have two kids, both of them are adults.
Yes.
Right? So let's say that when your youngest child turned 18, and is it a boy or a girl?
Girl.
Girl. Your youngest child, your daughter here is a girl. So when she turned 18, guess what? She doesn't need your permission anymore, right? She doesn't necessarily have to give you her private medical information if she, God forbid, got injured here. you no longer have those rights as a parent, those automatic rights. So it's not necessarily for the rich, it's for adults. As soon as you are turning 18, you should have at least a will. You should have a power of attorney. You should have a healthcare directive to help dictate the individuals that you would want to make decisions for you if you can't do so yourself. So again, a lot of 18-year-olds out there, right? They're not the multi-millionaires, but again, once you turn 18, you specifically should have those instruments in place. And again, there's this misnomer that, hey, Mark, like we're just like a married couple. We just have a home, have a couple of retirement accounts. Everything is going to go to our one child. We don't need anything, right? Well, you still will, because you want to make sure you are specifically spelling out it goes to your one child. You don't want to have them go through this probate process here, right? Have everything in a trust, put all your assets in a trust, no matter how large or how meager you think you may have, put everything in a trust. The trusts are the best ways to help achieve this legacy that you are going to be leaving behind. Because if you don't do this, there's going to be a lot of these other consequences that will come up that could have been all avoided. It'd be costing a lot of money, cost a lot of time, cost a lot of headaches if these things haven't been planned in preparation in advance for all of this.
You mentioned meager amount,
Yeah.
but that's a relative term, I believe. So how much is the minimum value of assets which should be recommended for estate planning?
Yeah. So when we say that, what is the minimum amount? You want to avoid probate. You want to avoid probate. So there's a threshold level here that California has specifically dictated. So California says that after 2025, April 2025, if you die and you have over $208,000 under your name, then your assets will necessarily go through probate. But if you had a trust and you put your assets into that trust, no matter how high that value is that you own, then that will bypass the probate system. So you're looking at around $208,000. If you own more than $208,000 of stuff, of assets, of properties, it's a good idea to create a trust. My basic rule of thumb, especially us here who live in San Diego, Southern California, if you own a home, you need to create a trust. You're in the real estate business. You understand, median value of a home right now in 2026 is $1 million here in San Diego. If you pass away and you don't do anything with your property, you don't put it in a trust, it will go through probate. And you're going to be spending about $50,000. Your kids will spend $50,000 to inherit that property.
You mentioned real estate. Some homeowners might ask, is Mark referring to the market value or the net value?
Yeah, great question. The courts, they don't care how much mortgage you owe on that home. They care the gross value of when you die. So it's going to be the market value. Yeah, they don't care if you're upside down on the mortgage. They don't care if you just recently acquired it and you only paid down like 2% of that thing, right? Nope. The courts will look at how much was your property value when the day that you died. If it exceeds that threshold level, then necessarily that asset will go through probate if it's not held in a trust, if there's no other probate avoidance mechanisms.
So we're talking mostly of tangible assets. Now let's go to intangible.
Yeah.
Do digital assets such as cryptocurrency, social media accounts, online banking get covered in traditional estate planning documents? Or is there a special process for such digital assets?
Yes, great question, especially nowadays where there's such a rise in cryptocurrency and non-tangible type of assets that you mentioned. So the key to that there, Jose, is to make sure that there is access to those assets after you pass away. So I have clients and I've drafted trusts for clients who have crypto accounts on certain different types of institutions, and those institutions are allowing those accounts to be held in the trust. So easy, right? It's like a bank account. It's like a home. You title that under the name of the trust. Other folks, though, are a little bit more, how should I say it? I guess a little bit more outside the traditional aspects where they want to be off the grid, so to speak. So they have those crypto wallets, right? A physical crypto wallet that it's not necessarily like in an account, it's just in their wallet, right? So the key way here to leverage an estate plan with some of those non-tangible assets is to be clearly defining who gets access to those assets, how to get access when you pass away. So we were able to help craft the language with all that in the trust, in the different types of instruments that we produce to make sure that, hey, when you're no longer around and you have these non-tangible assets such as crypto, such as social media accounts, such as whatever, there's going to be a way for the trustee, the next manager, to be able to access that for the benefit of the beneficiaries.
Now, this next question, I think, affects a lot of people who are trying to save money,
Yeah.
who don't want to spend on attorney's fees.
I get it.
So, has artificial intelligence, or AI, and online estate planning do-it-yourself tools disrupted the industry of estate law practice?
It has disrupted it in a way here where, frankly, Jose, I'm getting a little bit more business. I don't know how many times I have seen do-it-yourself type of trusts, do-it-yourself type of instruments come across my desk, and I immediately see the errors and the red flags in all of it. Necessarily, when I review these instruments, I tell them, hey, this plan doesn't work. Jose, imagine you're like on ChatGPT or you're doing one of those types of do-it-yourself types of things, and it just asks you questions, right? And yeah, you may think that you are selecting the right thing, but you know the adage, you don't know what you don't know. You could be selecting something that has vast consequences of something that you may not want to have happen, such as these unintended consequences. So it's always good to go check out and have a consultation with a qualified attorney. Again, a qualified attorney. Doesn't mean that any attorney can assist with these kind of things. As you know, the world is very specialized, right? If, God forbid, you were to get pulled over because you were drinking at 2 a.m. in the morning and you tried calling me to ask for assistance, legal assistance, guess what? I can't help you. I'm not that kind of attorney. But if you need assistance in crafting a will, crafting an estate plan that will work, I'm your guy because I know how those things specifically will work out, right? AI, do-it-yourself type of mechanisms, they're all made by computer scientists here, right? Again, these are necessarily customized. It's really, really behooves everybody to do something that's more customized rather than a cookie cutter type of thing, because again, you don't know what you don't know and you don't want to suffer unnecessary consequences.
What is the biggest mistake on estate planning you have seen that completely derailed a family inheritance?
Yeah.
And how could it have been avoided?
Yeah. Several factors here, Jose, and I appreciate the question. So oftentimes there's families, very well-to-do families. Let's just say that there's 3 children and they want to divide everything equally. That sounds great, right? In theory. And they don't want to choose any favorites among the 3. So they're going to have all 3 work together and be the successor trustees to manage the trust after they pass away. Again, in theory, it sounds great. But usually when I discuss these items with the clients, inevitably some cracks show up. Jose, imagine having to work with 2 other people, having strict unanimity on everything that needs to be done in an important process, such as such as trust administration, it's going to be rare for that to happen. There's too many cooks in the kitchen. Whenever I speak with the clients here, I want to get to know them on a deeper level. I want to know the dynamics, the relationships of all the family members in a really deep manner. Because if we are putting, for example, more than one person in that role of successor trustee, we may be doing the family a disservice, because we may necessarily be putting and forcing people to work together that naturally they don't want to. Maybe there's disagreements, maybe the siblings just don't like each other, and forcing them in this type of way just does not do the family any good. So it's really just a matter of having one person be the one that manages all this. By no means is that person going to be the favorite of the kids, for example, but you have to make sure that that person is responsible enough to proceed with the job here, right? To proceed with the job. So that's going to be one of those avenues. Hey, having more than one person be listed as a successor trustee. Another issue is, hey, they may not include all the children in the trust instrument. So sometimes some clients, they would have X number of kids, but when I talk to them a little bit more and I ask, hey, are these the only kids that you have, biological or adopted? Sometimes some of them will say, oh yeah, you know what? I do have another child, but I haven't spoken to that child in 20 years. The child is dead to me. Well, if we don't necessarily include all of the biological or all of the adopted children on that instrument, issues will arise later on, meaning that that person that was omitted, they could have a stake in this trust, in this estate, that the parents may not necessarily want. So again, the issues that come up with here is if the plan was done hastily, if it was done by some sort of program here, right, that you don't have that personal touch, because again, some of these unplanned types of ramifications can come into being.
I'll have a couple more questions about omitting a child or heir, but we'll get to that later. What advice would you give to someone who is hesitant to start the estate planning process?
Yeah. So, again, you and I are Filipino, right? There's like this taboo about, oh man, I don't want to talk about my death because if I do, then something will happen, right? So again, totally respect that, totally understand it. But it's wise to face the reality of our own mortality here, right? There is going to be a day when we are no longer going to be around, and there's going to be a day that we will not be here. And despite what we may be telling our kids, despite what our parents may be telling us of who gets what, who's going to be in charge, if that's not crystallized in writing, again, families are just going to disintegrate. There's no clarity involved with all of this, right? So you just want to make sure here that, yes, I understand the hesitancy. I understand why people don't want to do this. This is not a fun topic, but inevitably, every family that I've helped, you can see after they sign off on this, there's this giant sigh of relief, because ultimately, this is going to be an act of love. Estate planning is an act of love. That, yeah, in all honesty, just get over the hesitancy. Get over yourself. This is not necessarily ultimately about you. This is about the people that you love, that you will leave behind. If you do in fact love them, if you do in fact care for them, this is something that ought to be done.
Now let's go to trusts.
Yeah.
Can you explain the different types of trusts and when each type may be appropriate?
Yeah. So the main types of trusts here are like revocable family trusts, which we often assist in helping out here. So those are the family trusts. Those are the typical trusts that you kind of see out there: probate avoidance, legacy planning, so on and so forth. And there's another type of trust called an irrevocable trust. Those are very, very complex types of things here, right? Where if folks want some measure of asset protection, if folks want to help reduce any type of federal tax liability if they want to provide a gifting avenue for multiple generations. Irrevocable trusts are going to be the way to go. The vast majority of people, though, Jose, should have at least a family trust, a revocable family trust that avoids probate, that considers legacy planning. Perhaps, depending on their situation, whether they're ultimately high up there in net worth, or if they have a very, very high-risk job or high-risk occupation, they may want to supplement that with an irrevocable trust. So that's why it's always good to consult with a qualified attorney to determine what type of trusts are going to be best for a client.
Now, what are the benefits of, besides what you were saying about maybe reducing tax liability, what are the benefits of creating a trust compared to simply writing a will?
Yeah, great point. So think of a trust as an entity. Think of the trust as this water bottle. The trust will contain several rules. Hey, how are the things going to be divided? How are who's going to be in charge? What are some of the certain conditions associated with the inheritance? So on and so forth. Everything that is titled in the trust, everything that's in the water bottle, right? From your home to your vehicles to any investment accounts that you may have, whatever it is, should be in the trust. Because if you pass away, and when you pass away, and things are properly in the trust, those assets in the trust will avoid probate. A will, however, does not avoid probate. So think of the will as just a compass. It helps guide who gets what. It's not an entity, it's not a container. You can certainly still have the same types of functions as far as, hey, I want the car to go to this person, I want the rest to be divided among the kids, I want the church or the zoo to get a part of this, whatever it is. You could include that in the will and also in the trust. But if you only have a will, nothing else, your estate will necessarily go through probate. So you want to, again, avoid probate. It's a lot of money, it's a lot of time, a lot of headaches.
Thank you. I want to go back to probate in a bit.
Yeah.
I know you mentioned something about federal tax or regarding revocable trusts. In general, how can trusts be used for reducing tax liability? In other words, you mentioned irrevocable has a tax advantage or a benefit. How about revocable?
Yeah.
Do they give any advantage or benefit?
So it depends here on how the trust is going to be constructed. If the trust specifically has tax favorable language on it, again, I don't want to bore your viewers with a lot of tax law, but there's a way to kind of have the tax basis on certain assets like properties be increased, be stepped up. So when ultimately those properties are going to be sold within the trust, there's not going to be much gain to have to pay to Uncle Sam. So revocable trust would have, appropriate revocable trusts would have that type of language. Irrevocable trusts, again, that's going to be usually reserved for incredibly high net worth individuals. And right now, if somebody passed away and they had net worth of over $14 million, anything beyond $14 million will be taxed at a 40% rate. But if it's held in an irrevocable trust, then that won't be counted against that type of valuation. So again, it's really, it can get incredibly complex. It can get really detailed with all this. It's best to consult a qualified attorney to help reconcile what is it that you want to have accomplished.
One last question about taxes.
Yeah.
When you mentioned, I know you mentioned federal tax. How about state tax?
So not necessarily. As far as so what I was talking about, the 14 million threshold, that's the federal government. That's the federal estate tax, also known as the death tax, right? So vast majority of people are under that 14 million. I know, Jose, you're just under that $14 million
way under
threshold there, right?
Yeah.
But so that's gonna be the federal law.
Okay.
California, we don't have an estate tax here in the state, actually. So because of the fiscal cliff that happened several years ago, there's no more state estate tax here when folks pass away. So there's nothing you really need to worry about in the state side of things.
The persons involved in a trust,
Yeah.
there's a trustee who manages the property or the trust. How can we avoid a trustee from abusing his or her powers?
Yeah, great point, great point. So a lot of this really comes with education here, Jose. It comes with a lot of education. I always tell my estate planning clients that, hey, don't be so in a rush to pick a trustee, because let's say that they're going to choose their oldest son, and that oldest son is the favorite son, right? Because he gets along well with everybody. That's great. That's fantastic. But we need to make sure that that person, once they step into the role of a trustee, they now have a job to do. They have all these certain duties, certain obligations. Part of that is not mismanaging trust assets, meaning that, hey, these assets need to be put into an interest-bearing account. The home needs to be sold, put into that account there, right? It needs to make some sort of interest, so on and so forth. So the first thing here is the foundational aspects. We need to educate the clients on selecting the appropriate trustee. If, however, that trustee somehow mismanages or does things that they're not supposed to do, well, the beneficiaries have a claim, have an action against that trustee. So they could take him to court, they could go through all of this to have him removed, impose sanctions, so on and so forth. So if the trust is properly created well and there's appropriate language there, there's going to be a lot of measures there to make sure the trustee is supposed to be doing what he or she is supposed to do.
Can a trust include real property located in a foreign country?
Not a U.S. trust, not a U.S. trust. So yeah, I have several clients who own properties in the Philippines, in Mexico, wherever else here, right? So unfortunately, we don't have treaties with those countries that allow a trust that was created here to have foreign property and assume that type of jurisdiction. So my typical recommendation is if folks own foreign-based real property, to consult with an attorney in that jurisdiction to help create an independent estate plan for that asset.
The estate planning attorney can collaborate with the
100%.
foreign attorney.
100%, yeah,
Okay.
we do that more often than not.
My next question affects a lot of our veterans. As you know, San Diego is home to many or plenty of veterans.
Yeah.
So I've heard some of them hesitate to create a trust because they want to know, or they don't know what the effects of a trust on the real estate tax discount for disabled veterans.
Yeah.
Is there any effect?
Zero effect. So yeah, I have a few clients too who are 100% disabled. They want to maintain that property tax basis, obviously. Putting it in a trust does not affect that whatsoever. Putting real property into a trust does not affect increasing or reappraising property taxes as well too. So again, so long as it's done appropriately and it's done correctly, property taxes should not be going up if, again, it's done appropriately here.
Okay, something related to property tax. When the decedent, when the grantor passes away and then the property goes to the beneficiaries, is there reassessment of the property?
It depends.
Oh,
It depends. So as you likely know, there was California Prop 13 that allows a child to inherit a parent's property and keeping that same property tax basis, right? So if parents purchased property back in the 50s, they passed away here a couple of years ago, the child, if he's going to be inheriting that property, they could fill out an application and the assessor's office will say, okay, great. You're going to keep the same property tax basis as your parents were paying back in the 50s. That has now been replaced by Proposition 19, Prop 19. So there's a modification to that where, yeah, the assessor's office will still grant that parent-child tax exclusion so long as two factors are going to be met. One is if the parent specifically lives at that home and is their primary place of residence. And the second one is if the child who's inheriting that property also uses it as their principal place of residence, right? So a lot of people here, they don't just have one home, they may have multiple properties, right? So regrettably, because of Prop 19, you're only able to keep that same property tax basis for the principal place of residence of your parents, so long as you also are going to be upholding that as your principal place of residence too. Any other rental property, any other income property will necessarily be reappraised.
Is a trust the only way to avoid probate?
Not at all, not at all. And I've seen this happen constantly where folks are scared, right, of going through probate. They see how much it costs, they see how long it takes, they see just the horror stories. So you know what they do there, Jose? They decide to put their kids on title. They say, oh my gosh, I don't want my kids to go through probate, so let me add them to my account. Let me add them to my house. Let me just go to the recorder's office and just sign off on a deed, right? You don't want to do that. You don't want to do that. You can still achieve probate avoidance without having to go through those measures of, again, adding people on title. Because as you know, when you add people on title here, yeah, if you pass away, you add your girls on title, and they survive you, yeah, they will inherit the property, right? But when you add them on title, that affects the property taxes. It will go up. It will go up. It will reappraise the property taxes. Also too, Jose, it opens it up to liability. Let's say, God forbid, that one of the kids gets sued, driving one day and hits somebody, they get sued. That judgment's going to go after all the property that kid owns, even if it is jointly owned by you. So again, there are ways to kind of Mickey Mouse and just avoid probate, but you have to understand that there are dire consequences into doing that.
Disinheriting a child is legally allowed in many jurisdictions for almost any reason or no reason at all. But it is an emotional and morally loaded decision.
Yeah.
Have you ever refused to draft a disinheritance provision because it may cross an ethical line for you personally? And what was the situation?
Yeah, very, very good question. Very good question. So whenever parents are thinking about disinheriting kids, it is a very loaded, it's a very emotional, tough question, because I'm sure they don't want to do that, right? They don't want to do that, but certain situations arise that they feel compelled to do so. Whether, again, there's a lot of stories associated with all of this. As far as my role in all this here, Jose, my role is to help be a counselor and a legal counselor and guide to the clients to make sure their plans actually work. What do I mean by that? I want to make sure that their estate doesn't have to see the courts. I want to make sure that when they pass away, this trust is going to be administered in a very clear, delineated, as stress-free as possible type of matter here, right? When we talk about parents disinheriting the kids, that naturally already brings up a lot of issues with kind of not satisfying those goals. So I do my best to not necessarily steer the clients away from disinheriting their kids, but I give them what the dose of reality will be. Hey, Mr. and Mrs. Smith, I totally understand that your son, Alex, just is not a good person, disrespected you, so on and so forth. I understand that. But if you disinherit him and he does not like his siblings, when you pass away, he will have the right to contest this and cause problems for your other kids here, right? Is that something that you don't want? Maybe not, right? So again, we try to work through those strategies involved. Hey, maybe we give a little bit of something to Alex so that if he contests and he fails and loses, then whatever he would have gotten will be such that he passed away before the parents. So there's a lot of strategies involved. I definitely appreciate and understand where the parents are coming from. Those wounds are deep. Those wounds hurt. But my job is to let them know and be transparent. Hey, look, I don't mean to necessarily denigrate your wishes, but my job is to let you know what the ramifications are. And if you're okay with those ramifications, I'm going to help you with that.
If one of your close relatives asked you to help them disinherit a child or sibling, what would be your response?
Yeah, that'd be a tough thing to swallow there, right? That'd be a really tough thing, especially if it's a close family member, if it's a close friend. I would have hopefully a little bit more emotional leeway in that to just kind of even give them a more harsher dose of reality with respect to, look, what is the ultimate goal here, right? Is the ultimate goal to just not give this disinherited person anything because you feel that they don't deserve it? Because if you feel they don't deserve it now, maybe there's other ways that we can still help them achieve that goal there, right? Of being responsible, so on and so forth. So that's a great question there. It's something that I have to take on a case-by-case basis. It all depends on like what is the relationship that I have with those people. Am I going to be necessarily embroiled? Am I included as like a trustee or somebody else of that nature there? So I don't think I have a clear answer to that. It will have to be a case-by-case basis, but I do stand by what I said as far as my job, especially in this role of being a estate planning attorney, is to ensure that the client, whether that's a stranger or that's going to be a close family friend or family here, of what the reality will be.
Now we shift to probate.
Okay.
Could you walk us through the probate process? What does it entail?
Yeah.
How long does it typically take? And how much does it cost?
So probate in California, it's a bear. There's a lot involved with probate because it's necessarily governed by the probate code. It's necessarily governed by the courts. So as far as timelines are concerned, it really varies here, Jose, it really does. The fastest probate could be done, completed fully, would probably be a little bit over a year, say like 14 months. But I've seen probates that have taken years to complete. It all depends on, again, the complexity. It all depends on the relationships of those folks that's going to be left behind. So it's a wide range of time, but it does take at least a year to be rectified here, right? In San Diego specifically, you likely know that we're a very populated county here. We are the 5th most populated county in America. Yet here in San Diego, we only have 4 probate judges. We just got the 4th one relatively recently. So it takes a while, right? Just a lot of logistics, a lot of congestion with moving things around. There's only 4 departments that governs the entire county here. So it takes a while. It is very expensive, very, very expensive. So as I discussed, it's all based on the fair market value of the assets that's being left behind. Again, you're in the real estate space. You understand that the average value of a home here in San Diego, $1 million, right? $1 million. So let's say you do a good job of putting beneficiaries on all of your accounts, on your life insurance, your vehicle, so on and so forth. But you can't just go to like a DMV and say, hey, I want this person to be my beneficiary, right? With a home, it's not as easy. So you pass away and your home goes to probate. For a $1 million home there, Jose, you're looking at about $23,000 for an attorney, the fees to go through all of that. Further, the judge will appoint somebody to be the personal representative, to be the administrator. That's going to be a person that you may not know. It's a person that you may not want handling your affairs. That person gets the same amount as the attorney. So right off the bat, for $1 million home, $46,000.
Wow.
We're not talking about all the filing fees, the court costs, appraisal costs, so on and so forth, publication fees. So you're looking at about over $50,000. $50,000 to administer going through probate for just an average value of a home here in San Diego. It's not pleasant. It's going to take, again, at least a little bit over a year to handle all of these affairs. Plus the emotional toils of this thing being in public and just things just not getting resolved. So probate is something you ideally want to avoid.
Besides the cost and time, what are the common challenges or issues which arise during probate?
Yeah, it's just a matter of leaving it all up to the judge here, right? It's a human being. Sometimes the judge may just not feel that the petition is up to par. And if that's the case, then things will be delayed. Things will be continued here, right? You can do everything you can, but again, the judge is going to be up to their discretion. You can file appeals, you can do all of that, but again, it's going to be a moot point at that time. Especially the public nature of all of this. Every probate matter, anybody here could just look at the file and see what's going on. Yeah, there's a lot of social media stuff going on right now, right? People want to put their business out there, but you don't want that business to be out there for public consumption. It's just not a very pleasant type of situation. So you don't want to leave things in the hands of a stranger like a judge. You don't want to put things out there for public consumption. And again, the thing about probate here, Jose, is that it is all avoidable. You don't want that regret to be lingering here, right? Where, oh gosh, I could have done something here, right? So those are the factors why you want to avoid it. Yeah.
Before we close the interview, could you share your contact information for our viewers, and if you have any message for them?
Yeah, certainly. So the best way to interact with us is going to our website, www.ignaciolaw.com. There's a lot of different resources there. We have a welcome video there as well. There's this thing called a probate calculator where you can enter your value of your assets, and if you have to go through probate, that's how much it's going to be costing there, right? So engage with the website. There's an opportunity there to register for a complimentary seminar to learn further about this process here, estate planning, probate, trust administration. By registering and attending a seminar, you're entitled to a fee discount. So we want to be able to help educate the public, and we want to reward them for their participation in these seminars by a gift of a specific fee discount in any of our estate planning services here. As far as the message is concerned, it's just really understanding that estate planning truly is an act of love. That a lot of what we do here, we applaud our clients so much because we recognize that, man, they love their kids, they love their family, they love their organizations, they love their church, who they're going to be giving it to, because they are spending the time right now to understand and think about these people that's not themselves. So if you're a kind of person here who you do absolutely love your family, you absolutely love your community, you want to display and put into action this element of love, estate planning is going to be one of those ways to help achieve that.
Thank you so much, Mark, for discussing this very important topic. I really appreciate it, and I'm sure a lot of our viewers appreciate it too. And if you found value from this episode, please hit the subscribe button. Thank you so much, and I'll see you next episode. Thank you, Mark.
Thank you, I appreciate it.